Perspective, presented by the New Orleans Secular Humanist Association, following a few principles of humanism.
We're committed to the use of science and reason for understanding the universe and for solving human problems. We're skeptical of untested claims of knowledge, but we're open to new ideas.
We are concerned with securing justice and fairness in society and in ending intolerance and discrimination. We are committed to the total separation of religion and government.
We affirm humanism as a realistic alternative to the theologies of despair and the ideologies of violence. We reject the concept of an afterlife and believe in living a full and rewarding life here and now.
We value and respect each individual's right to judge and lead their lives according to their own position, as long as it's respectful of other people living in a free society.
We hope you enjoy today's program and others in the weeks to follow.
Good evening and welcome to another episode of The Humanist Perspective. I'm Jim Dugan, Vice President of the New Orleans Secular Humanist Association. I'll be your host this evening. Our guest this evening is someone we're always very happy to have on the program. Marjorie Esman has been the Executive Director of the ACLU of Louisiana since September of 2007, after 20 years in private practice of law. In addition to her Tulane law degree, Ms. Esman holds an undergraduate degree from Cornell University and a PhD in anthropology from Tulane, and has taught at Tulane, LSU, and the University of Southwestern Louisiana, now the University of Louisiana at Lafayette. Marjorie, thank you so much for coming this evening.
It's always a pleasure. It's always a pleasure.
There certainly are plenty of current issues that we could talk about. One of these is the unfortunate killing of Alton Sterling in Baton Rouge and the protests that have revolved around that. And we know that the ACLU has been involved in a lawsuit about that. Can you tell us a little bit about what's going on?
Well, sure. First of all, as everybody knows, the killing of Alton Sterling was part of a nationwide problem of overreacting to law enforcement calls involving black men. He's one of a string. You know, everybody knows the names of the many who have predeceased him at the hands of police. And as a result of that really tragic breakdown of trust between communities of color and law enforcement, there have been in Baton Rouge, as in other parts of the country, protests against the way the police reacted in a way that led to Mr. Sterling's death. And because the ACLU exists to protect and defend everybody's constitutional rights in this country, that includes the First Amendment right to protest. Our Constitution gives us the right to peaceably assemble and to petition the government for redress of grievances. Peacefully, of course, is critical to that, but it means we have the right to protest. We have the right to complain when our government doesn't do what we think it should have done. And what happened in Baton Rouge, unfortunately, was that after a very peaceful demonstration march, the Sunday after Mr. Sterling's death, when I was there and I saw the police and the crowd both were on absolute best behavior. There was no antagonism on either side. Everybody was very respectful of one another. And then the official part of the march ended, and people were still milling around. They weren't quite all ready to go home. It was early on a Sunday evening. People still had a lot on their minds. And all of a sudden, the police came out decked out in riot gear. We have a problem in this country with over-militarization of police. We see that in communities around the country. We've seen it in New Orleans, not in this context, but in other contexts. And as a result of that, things went downhill quickly. What we know is that a couple of hundred people were arrested. We now know that the district attorney has decided not to file charges against more than half of those, which means that those arrests really didn't need to have happened. We had protesters who were snatched off of private property into the street and then arrested for being in the street. people who were told to get out of the street, but the streets were blocked off. There was no way they could get out of the street, and then they were arrested for not getting out of the street when there was nowhere for them to go. There were people who were injured at the hands of the police. And as a result of all of those things together, the ACLU of Louisiana, along with some other organizations, we're not in this by ourselves, filed a suit against all of the law enforcement agencies in Baton Rouge, basically to ensure that they, going forward, will respect the First Amendment rights of people to engage in peaceful protest. We're not talking about violence here. We're talking about peaceful protests. That right was not respected that Sunday evening in Baton Rouge, and we need to make sure that it's respected in the future.
So this actually sounds like a fairly complicated legal issue. On the one hand, or maybe that's just me as an amateur, right?
It should be pretty simple, actually.
Well,
it should be
that's
pretty
good to
simple.
know.
The First Amendment says you have the right, to engage in peaceful assembly, and it should be pretty clear. It didn't happen like that. But of course, it's never simple because there are always the individual stories and, who says what about who did what, and so it's never simple.
So the First Amendment guarantees free speech.
Right.
And if we look at that, you won't see the word protest in there anywhere, but somehow this is protected by precedents
the
that
right
have been
to peaceably assemble means you get to, I would say the First Amendment, if you put it in kind of, contemporary jargon, it gives you the right to say what you want, pray how you want, and hang with who you want.
Mm-hmm.
The right to peaceably assemble means that you have the right to get together with anybody you want. Mm-hmm. And you also have the right to petition the government for redress of your grievances. That means protest. That means complain that you don't like what the government did. So no, it doesn't say protest, but that's what it means, and it has been, understood to mean that ever since, we had a constitution. I mean, it's very clear that that's what it means.
So, and there must always be some tension for the police, who are fairly concerned with public safety and maintaining basic order, trying to find a balancing point with the right to speak out.
Well, one problem is that we have overly militarized our police in the past 8 or 10 years. We have police departments, including Baton Rouge, that have received gear that is really designed for military uses. And they have it, they've gotten it through special grants from the federal government, so they now have this equipment. They have these assault rifles, and they have these gas masks, and this armor, and these vehicles, and they have it. And so now they have it, they feel like they need to use it. The fact is, it is true that there was a permit for a particular route for the march. That permit covered a particular scope of time and a particular set of streets. What happened afterwards was outside the area that had been blocked off. There's no question about that. But what the police could have done, and what they did do successfully in other cities, would be to acknowledge that the crowd was not ready to disperse. To acknowledge that in order to protect everyone, it would be appropriate for them to work out an alternative route that they could protect both the general public and the marchers, so that the march could continue in a peaceful way. They were given the opportunity to do that, and they refused. And so what you ended up with was a crowd that was angry because they wanted to continue to march and they were not permitted to do that, and a police force that overreacted when it could have been handled very differently and should have been handled very differently. And it's unfortunate. It's led to tragic results, and that's really unfortunate.
So you don't just have a right to protest when you, after you gotten a permit and filed the paperwork, you're saying?
Well, you have the right, everybody has the right to basically, protest in any way they want, but not to block off streets. So you can stand on the sidewalk because you're not obstructing traffic that way. You can't block other people's right to use the sidewalk, but you can stand on the sidewalk and you can hold signs and you can chant and you can do whatever. What you can't do is get in the street and block traffic. And that's, really a public safety issue. It's dangerous for you standing in the middle of the street, and it's dangerous for people who may need to use the street in order to get wherever they may need to go, including possibly the hospital or something like that. So there are reasons why permits are appropriate. Still, it was a Sunday evening. It was downtown Baton Rouge. The streets were quiet, and there could have been a way to work out something that would have satisfied the concerns of the crowd and still allowed the police to maintain public order. And the police chose not to engage in those conversations, and that's too bad.
And some of this has to do with the fact that after the permit time had elapsed, people were actually on private property. Is that correct?
Well, at one point, after things started to go bad, there was a woman who invited the protesters onto her property to give them a space where they could continue to protest and to be safe from the police. So at that point, they were her guests. They were her invitees. And the police went onto that property. At that point, on private property, you need a warrant. They did not have a warrant. And they went on there and started snatching people out of the crowd, pulling them into the street, and then arresting them. And, you know, on private property, you know, you have the right to do what you want as long as it's not hurting anyone else. And if the police want to go onto your private property, they have to either basically see a crime in the process of taking place, or they need to have a warrant. There's a reason for that. You know, all of this is about protecting the people from overreaching by the government. That's what all of this is about. It's about it's about ensuring that we don't end up living in a police state. And unfortunately, things didn't happen like they should have in Baton Rouge that night.
So you mentioned that probably close to half of the arrests have been dismissed.
More than half. More than half. At present time. And what the DA said was that he was going to continue to review the others and decide whether there were any others that might also need to be dismissed. So,
do you think they're going to dismiss them all? Or?
You know, I'm sure there are a few that might be justified, and I certainly don't want to second guess what the district attorney is going to do. But the fact that they have taken at least half of them and dismissed them means, I think that speaks volumes in itself, that the police clearly were overreacting.
And if your suit were to succeed, would this be mostly just a matter of establishing a legal clarity in people's minds, or would you propose some kind of training? What would this entail?
We haven't asked for training. You know, we hope that I think it's very clear there have been problems over a period of time with the police in Baton Rouge not knowing things that perhaps they should know. There was a time several years ago, people may remember, when they were arresting people in a public park for soliciting, basically for asking for dates, really. But they were being arrested for solicitation of sodomy.
But they were leaving the premises and going into private spaces.
That's right. They were not doing anything, you know, improper in the public space. They were merely, really, essentially, you know, picking one another up and soliciting for dates. But they were arrested under a law that the Supreme Court struck down many years ago. It was not an enforceable law, and yet those arrests were made. And so it's clear between that and what happened this past week that additional training would be appropriate for officers in Baton Rouge. That's not what this lawsuit has asked for, though. What we've asked for is assurances, and we want the court to order that the kinds of violations that happen will not happen again, that the rights of protesters will be protected, that, you know, when the police came out with gas masks, that sent a message that they were planning on using chemical weapons. They didn't. But why else would they have had gas masks if they weren't preparing to use something that they themselves did not want to breathe in? And so we've asked to make sure that before anything like that can be used, that there needs to be clearance from the governor, so that it has to be done under a deliberative process and not based on an emotional reaction. There are some other things too, but we basically just want the court to sort of clarify for the Baton Rouge police what the requirements are so that they will know what they're supposed to do going forward.
I'm sure there are many topics we could cover this evening, things that are very current events kind of things. One of the other topics, if I can move on.
Please, I'm sure there's lots to say.
A current decision, a recent decision from the Supreme Court had to do with abortion in the United States.
Yes.
This is a really big deal with impact around the country, including here in Louisiana. Can you tell us a little bit?
Yes, the Texas abortion decision that just came down very recently, in which the Supreme Court struck down a series of laws that had been enacted in Texas and have also been enacted in Louisiana that are no longer enforceable here, specifically around requiring doctors to have hospital admitting privileges and requiring abortion clinics to maintain standards equivalent to outpatient surgical clinics. And those laws were very clearly not enacted for the purpose of maintaining or protecting anyone's health. There was no medical justification for those laws. The record was very clear when they were enacted that they were not enacted based on medical necessity, because there is no medical necessity for either of them for a large variety of reasons. And the Supreme Court came down very hard on that, and they said in no uncertain terms that anything that's adopted essentially as a pretext to interfere with a woman's constitutional right to control her own reproductive decisions is presumptively invalid. And what that means is that those laws in Louisiana now, are no longer enforceable, the hospital admitting privileges and the surgical suites. But there's been a lawsuit filed, not by the ACLU, but by the Center for Reproductive Rights, which has handled most of the abortion rights litigation in Louisiana over a long period of time. They're very experienced in this. And they almost immediately filed a law challenging a whole host of other Louisiana restrictions, like the 72-hour waiting period and the need to have an ultrasound and some other things, which were clearly also enacted not because there's any medical justification for them, but clearly as intents to make it more and more difficult for women to have a procedure that they have the legal right to have. And I expect that lawsuit will succeed. I can't imagine, having read what the Supreme Court just said, that they will contradict themselves going forward. And so this is really, a very important and powerful statement, the first one in a long time that's been so powerfully come down in favor, once again, of women's right to control their own reproductive decisions in consultation with their doctor and without the intrusion of a bunch of lawmakers who may not like it but don't have the legal right to interfere.
The many laws that have kind of sprouted up around the country for years now, at least a decade, they've been working on trying to narrow and limit a woman's access to abortion, and making up these false medical justifications for it, claiming that this is to protect a woman's health. And
it's clearly not.
And it's clearly not. And the interesting thing to me is the court was very much willing to call that bluff, was very much willing to say, no, this is not credible. Your claim that there's a medical reason for this just doesn't hold up.
No, and part of that is because there are all manner of other medical procedures that are far riskier than an abortion, which is not to say that they're risky, but it is to say that abortion is extraordinarily safe. And those procedures can be done on an outpatient basis in a doctor's office without any of these requirements at all. I mean, sort of the classic example that people use is a colonoscopy, which, is routine, highly recommended for people over a certain age. It's a very safe procedure. And yet, even as safe as it is, it has a higher risk factor than abortion does. But doctors who perform colonoscopies do not have to have either hospital admitting privileges or these kinds of requirements for the way their medical offices have to be outfitted. And so clearly it wasn't about medical safety. And that's right. The Supreme Court was very ready to say this is pretext. It's absolute pretext. And so I anticipate that things will get much better in Louisiana for women who need abortion services.
One of the things that is always confusing to me is trying to wade through the dissenting opinion on a matter like this. Some of the more conservative justices want the courts to defer much more to legislatures on these. They seem to want courts not to test some of these medical facts. They want to make them a rubber stamp for legislatures. What's the how do we? I don't understand it very well. You understand it better than I do.
There's always this tension between the states and the feds, and particularly when it comes to the Supreme Court that wants to overturn things that states have done. But depending on which side you're on, you either want the states to be in control or you don't want the states to be in control. More often than not, on these kind of social issues, conservative states don't want the Supreme Court weighing in. I mean, we've of course seen that relatively recent with the same-sex marriage issues, where they say it should be up to the states. This has always been a states issue. States have the unique authority under our Constitution to regulate what constitutes marriage. It's not the Supreme Court's business. And that same argument is playing out here, but the federal courts have the obligation to weigh in when something is being done for a pretextual reason or when people are being denied fundamental constitutional rights, like equal protection, like due process, like your right to privacy. These things are fundamental rights that all Americans share. And they don't change according to whatever state you live in. You have them by virtue of living in this country.
Right, and I think that's a very important aspect of this issue, is that the court isn't just investigating a state finding on some business matter. This is the right to privacy in abortion has been very well established.
That's right. These are fundamental constitutional rights that we all share, and it is the job of the Supreme Court to enforce those rights so that every person in this country gets the equal benefit of them. That's what their function is. That's what their job is. And we have to remember that they're there to protect all of us from the kind of government overreaching that could lead us to a totalitarian state.
And what do you think will be happening in Louisiana? Now, you mentioned a suit that's in process. How long do you think this is going to take? Is there going to be more back and forth with women's access here in Louisiana?
Well,
is it going to go fast?
With respect to litigation, litigation is always slow. Lawsuits are never over quickly because, as far as I know, there's no hearing date set on this. But even if there were, whichever side loses is going to appeal. And so we're looking at, before this lawsuit is resolved, we're looking at years. 2, 3, maybe.
But at the moment.
But in the meantime, what we know is that the laws that Louisiana has that are identical to the ones that were struck down in Texas are not enforceable. We know that. The rest of these laws were not specifically challenged in the Texas litigation. The Supreme Court has not specifically ruled on such things as ultrasound. And so that's up to interpretation, and that will take some time. But certainly, access has just become much easier for a lot of women in Louisiana.
And how are we operating right now legally in Louisiana? Where does are these are going on? I mean, women have access to abortion right now in Louisiana.
The thing about the right to abortion, or the right to anything actually, is it's only as good as your ability to exercise it. And there are some clinics that were shut down by these laws, and the extent to which they can reopen is really a monetary decision. And so there are still communities in this state where the right is essentially a meaningless right, because it does you no good to have the right to get something that you cannot access because of where you live.
So in part, a business or even a nonprofit has to have enough activity going on to be able to afford to set this up. And if the legality is uncertain, they're going to be hesitant about that.
That's right. That's right. So we're a long way from where we should be in terms of the ability of people to access something that they have a constitutional right to have. But where we are now, where we were not sometime several months ago, is that at least that right has been restored for a woman to go to a doctor in a doctor's office without admitting privileges to a hospital, which are unnecessary, without all of these other extraneous factors. And if the doctor is willing to perform an abortion, the woman has the legal right to have it. So that's, it's not as good as it should be, but it's better than it was.
And a really big step has occurred here.
That's right. And the Supreme Court, if nothing else, they were very, very strong in their language that abortion is and remains a fundamental constitutional right, and it cannot be undermined on pretext. And that was very strong language. So that's a good thing for all of the women in this country.
I think we have a few more minutes yet.
Okay.
I would like to move on to another current topic.
Sure, there's lots of
I'll try to squeeze a few things in here. New Orleans has had an ongoing problem with Orleans Parish Prison and the Sheriff's Office, and a lot of contention over this. And I know that there was a settlement recently with the Federal Department of Justice, am I right?
Yes, and with the plaintiffs who were represented by the MacArthur Center for Justice, who sued the prison years ago and have been fighting this
and this has been going on for
many years.
And this is about treatment of prisoners.
Well, it's about treatment of prisoners. It's about the way the sheriff has been managing the jail in an unconstitutional way. And the settlement essentially requires the appointment of somebody who's going to be called a compliance monitor, I believe is the title, who is to be chosen by the plaintiffs groups, the Department of Justice. There will be a short list of 3 names to be submitted to Sheriff Guzman, who will choose the one out of the 3 chosen by the plaintiffs in the lawsuit, but then subject to the approval of the court, which is Judge Lance Afric in the federal court here in New Orleans. And once that person is selected, that person will essentially take control of the operations of the Orleans Parish Prison. Will be able to make the decisions that will make it safer, accountable only to the federal court and not to anybody else, not to the voters, not to politicians, not to anybody else. And so it will essentially be taking the authority away from Sheriff Guzman, who clearly has not been able to use that authority effectively.
So this monitor will, does he have direct control? Is he just paying attention? Does he have to just get reports? And
No. We'll be in direct control. We'll be managing the prison, making the decisions, and reporting to the federal court.
So he has to go from time to time before a federal judge and say, this is what's going right and this is what's going
that's right.
wrong.
We'll have to submit regular reports, I think quarterly, I'm not sure about the timing, to the federal court, but we'll have the authority to make the decisions to improve conditions that really have been allowed to languish in a terrible state for far too long.
Some of this was about temperature in the building?
Well,
or is that
no. I think you're confusing that with Angola.
No, help me understand that.
But it's about access to medical care. It's about mistreatment by the guards. It's about neglect of the guards that have allowed inmates to continue to engage in violence against one another. There have continued to be suicides in the jail, which means that the guards are not properly watching over the people they're supposed to be watching. There's a whole host of things that were supposed to have been improved. The sheriff kept saying for years, once he got the new prison on board, once the new building was built, everything would get better. And he got the new building a couple of years ago, and things are still not better. And so it's very clear that it's no longer about the building, it's now about who's in charge.
And this is always against a background of funding and tension with the city and the state?
Well, the sheriff has complained that he can't hire better guards because the city won't allocate enough money to pay them an adequate wage. And it is true that they don't get paid enough. But it is also true that there are all sorts of things that have happened in that jail that have nothing to do with how much the guards are paid, and everything to do with the fact that he's not paying attention and has not fixed what's been very badly broken.
Marjorie Esman, thank you so much for another interesting episode of The Humanist Perspective. Thank you all for watching, and we'll see you again soon.